Good morning, respected all. I'm Dr. Pooja Verma, working as an assistant professor in School of Education at K.R. Mangalam University. I welcome you all to the fifth session of one-week interdisciplinary FDP on meaningful research and intellectual property rights. This FDP is being organized by School of Education, K.R. Mangalam University, in collaboration with Faculty of Education, Chaudhry Charan Singh University from 8th August to 14th August 2022. I recently heard that Freedom Fest is live on Myntra, and suddenly I was able to visualize that logo, that M filled with pink and orange light color. That symbol is the trademark for Myntra. I have also heard many YouTubers complaining that their video are being removed as they have got copyright strike. So to learn more about them, I take this opportunity to welcome Dr. Parikshet Sirohi to embrace this session with his insight into copyright and trademarks. We welcome you, sir. So before going ahead with the session, I should introduce you all to Dr. Sirohi. Dr. Parikshet Sirohi is an assistant professor in Faculty of Law, University of Delhi. His area of interest are intellectual property law, food security law, constitutional law, right to information law, competition law, cyber law, criminal law, law of evidence. In his 9.5 years of experience, he has taught the subjects of intellectual property rights, constitutional law, law of evidence, public international law, cyber law, competition law, business regulation, and many more. He has presented research papers at various seminars and workshops, published articles in reputed journals, and judged moot court competition at various institutions across the country. He has delivered lectures at several prestigious institutes like National Law University and judicial academies at several states. He has been invited to deliver lecture at Competition Commission of India, Academy of Administration, Bhopal, Haryana Institute of Public Administration, Department of Science and Technology, Government of Rajasthan, CBI Academy, Ghaziabad. He has been a visiting faculty for LLM IPR program of the Maharaja Surajmal Bridge University, Bharatpur during the year 2017 to 2020. He has supervised 10 LLM dissertations and is currently supervising 2 PhD theses. An avid debater and scholar since his school days, Dr. Sirohi has authored a book titled Interface of Design Law with Copyright Law and Trademark Law. He has co-edited another book titled A Critical Approach to the Right to Information Legislation in India. He has also contributed book chapter to various national and international publications. He has also contributed, and is presently working on his book in the area of food security law. He currently heads the Placement and Internship Committee of Law Center 2 or 2nd, University of Delhi. He successfully organized 4th KK Luthra Memorial International Moot Court competition, which witnessed participation from teams belonging to 70 institutions in India and teams from outside India also. Dr. Sirohi has been associated with drafting Mental Health Act 2017. He currently serves as a member of the Oversight Committee to monitor the implementation of aforementioned legislation. He has also had his own independent legal practice and has served as Central Government Counsel in Supreme Court of India and in the Delhi High Court. He has experience of serving as legal advisor of a union government appointed inquiry team, which undertook an investigation in the legal alleged sex change operation performed on infants in Indore, Madhya Pradesh in the year 2011. During his years at the bar, he has handled PILs and has represented many central government ministries. So we welcome you, sir.
Thank you, Pooja ji. Thank you for the kind words.
So, sir, may I invite Dr. Tanya Gupta, Dean SOED, for the welcome address?
Please, ma'am.
Yeah, thank you, Dr. Pooja. Good morning, Dr. Parikshet ji. You are, as you know, when we started the session, you've already been a part of KR Mangalam, and you mentioned being associated with our School of Law. It's our fortune that today you are associating with the School of Education as well. And in fact, the entire university, because we understand that how important it is, today in the perspective of knowing, having a good knowledge about the IPR, the intellectual property rights. And Pooja has already introduced you a rich profile, and we are very happy. And I would like to welcome you on behalf of our, the patrons of this FDP, the Vice Chancellor of KR Mangalam University and the Vice Chancellor of C.C.S University, Meerut, as well as our co-patrons, the Pro-Vice Chancellors, and also on our behalf at the School of Education, KR Mangalam University, as well as on behalf of Professor Jaiswal, sir, who will join maybe shortly, as I mentioned. He's heading the Faculty of Education at C.C.S University, Meerut. So we are very happy to have you with us. And as you know, this FDP is, this is day 5 of the FDP. And just to brief you, we've had sessions on basics of IPR, and we've also had a session on how one has to go about systematic approach to writing research articles, indexing and citation. We had a session on filing of patents and documentation procedures, industrial designs and geographical indication. Yesterday was a festival day, so our participants undertook an assignment yesterday on the 3 days, whatever they understood from the sessions of the speakers. And today here on day 5, we have you on, again, a very important topic, that is, understanding copyrights and trademark. So I welcome you, sir, and we are all keen on listening to you. And soon after your session is over, we will move ahead with the question answer session, if that would be okay with you.
Absolutely, absolutely, ma'am.
So welcome once again, sir.
Thank you very much, ma'am. And so what I will do is I will just share my screen. I hope technology helps me again, because I'm not very good at all this. So, okay, I managed, I think. So is my screen visible, ma'am?
Yes, sir. It's visible.
So, thank you, Dr. Pooja. So at the outset, I must thank the organizers, Professor Tanya, Professor Jaiswal, both the universities, CCS and KR Mangalam, Professor Jaina, Dr. Pooja, Dr. Anshul, who's been coordinating with me. Thank you very much for having me here. And I must compliment you for organizing a program like this. And I have also seen the topics which you have selected. I've been through, ma'am has just taken us through the topics that have already been discussed by the previous speakers in great detail. You've had a full session on patents. The participants are actually lucky that way, that the session has been curated, the program rather has been curated in such a manner that, all these important topics, significant topics from the diverse areas of, in fact, generally GI design, we don't talk much about it. Generally we concentrate patents, copyright, trademark. So, the organizers have taken the reins and gone ahead and done that. And it's also significant that you are doing this at a time when we are celebrating Azadi Ka Amrit Mahotsav, 75 years of Indian independence, because the Honorable Prime Minister is now talking a lot about IPR. And people down the line consequently are talking a lot about IPRs, because I know you've had already a session on the basics. Are you okay if I continue only in English, or do you want me to mix both English and Hindi? I can do it either way. How would you want it?
We are absolutely fine, sir. You can be completely in English. There's no issues. And if you want to be bilingual, we are equally comfortable.
Fair enough. Perfectly okay. So, I have, gone through the sessions, etc. I mean, the material or the topics that is being circulated. I mean, it has been talked about. So I have a fair idea of what has been done in the previous days, and I must say that everything really that is important has already been talked about. So I am not going to try and reinvent the wheel today. I am going to talk about what I think
मैम ही इज रिकनेक्टिंग बिकॉज इलेक्ट्रिसिटी गॉन तो उसकी वजह से प्रॉब्लम थी ही इज जस्ट रिकनेक्टिंग
No issues. We can wait, please. No problem. So in the meantime, till Sir joins in, this is a little announcement for all the participants that uh, we anticipate that the participants attend the all the sessions of this FTP. It's a very beneficial FTP because you know that the importance of filing patents and the documentation procedure. I mean, almost all the stakeholders in higher education require this as in terms of the quality perspective. And it's now not only just about writing research papers or publishing in index journals, but it is also about contributing in a way to design something new and bring in, to add to the body of knowledge as well as something having a social impact as well. So it's an earnest request to all the participants. Firstly, we are grateful that you're taking out time to attend this faculty development program. But we'll be very, very happy if we get a good response from all of you daily, because successful completion of the FDP is very important. And we should be here for the sessions, as well as we also request you to be very prompt in giving us your constructive feedback for improvement of the sessions. We do see that sometimes there can be technical glitches because of whatsoever reason, but we also look forward for your constructive feedback, and kindly do fill the feedback forms on a daily basis. And I hope all the participants have also done the assignment. So this was just a little, I just told the time till Dr. Parikshet is back. So we'll be more than happy that if all the participants make the best use of this FTP. So Dr. Parikshet, you're back, sir.
Yes. Yeah, just a moment. I'm just trying to turn on the video. I apologize. The electricity had gone. So I just Dr. Pooja. Technology is treacherous. So just my apologies, ma'am.
No problem, sir. We can see your slides. We'll just request if it is resumed on the slideshow mode.
Yes. Yes. I will just, yes. Now you can see me and you can see the slides.
Yes, sir.
Yeah.
So, yes. Okay, so yes, so I was mentioning the matter which has already been covered. I will try not to touch upon it, and because I don't want to reinvent the wheel. I will directly dive into what my agenda for today is. So I'm going to deal with both copyright and trademark. And since we are all teachers over here, I will also talk a little bit about plagiarism. Because plagiarism is, I know you've had a session on plagiarism, but I will try and deal with plagiarism a little differently from the point of view of copyright. So, and the origins of plagiarism and how much importance it has and so on and so forth. So, the introduction to copyright, first of all, what is copyright? Now, we ask this in our exams. We teach through the case method, we teach cases, and then we ask the student to write the law. the first question is invariably about this, and the student writes, copyright means right to copy. Is it wrong? No, it is not wrong. But if you just say copyright is right to copy, I'm sorry to say it's a turn off for the examiner. It's like the first question, the first line, copyright is right to copy, full stop. Yes, it is right to copy, subject to certain limitations. What are those limitations? You need the permission of the author, the owner, whatever as the case may be, and he has to authorize you for it. He may give it to you out of natural love and affection, or he may charge you some kind of a royalty, which is money, to use it. So for example, if I were to write a book and you were to quote from it, you have to take my permission from it. Yes, bona fide academic use, writing a research paper, all of that is perfectly okay, as long as it is acknowledged and as long as it is within decent limits. You can't pick up the entire part of the 80% part or 30% part of the book and say it's, I'm doing it for research. No. The basis of copyright law is actually in the Bible. The 8th commandment says, thou shalt not steal. That is Old English. आज हम shalt नहीं लिखते, shall लिखते हैं. So thou shall not steal what? The fruits of another man's labor. दूसरे की मेहनत का हम नहीं लेंगे. That is the basic purpose. So दूसरे के काम को हम अपना करके, we will not. The idea is that so in IPR, there are two kinds of IP. There is industrial IP, and then there is non-industrial IP. So when we say industrial IP, we are concerned with stuff which is important to the industry. Patents, trademarks. Patents, why I said that is the most important for industry. That is why if you see the TRIPS negotiations, the 1994 Uruguay round, the General Agreement on Trade and Tariffs, you see all of that. Bulk of the importance is given to patents. So because everybody wanted to discuss patents. So that is of primary use to the industry. Then trademark is of use to the industry. GI is of use to the industry. Copyright is of no use to industry. Copyright is for, plays, books, art, computer programs. So whenever we see Microsoft antivirus, we'll say copyright Microsoft Corporation. Right? A C with a round, that is the symbol that you're asserting your copyright. Please go back and see, I am asserting my copyright. See, before my name, just below the KR Mangalam logo, I have put this C symbol. I am asserting my copyright. This is my work. You are free to use it, but please quote me. Okay. So this is what you should do whenever you are making presentations. Whenever you are writing, your LLM, your MPhil dissertation or any kind of dissertation, any kind of thesis, it is all your copyright. And you can obtain a copyright. It is not a long procedure. I will just show you how you can do that. It's a simple, straightforward procedure. And the idea is that the essential works of art, which do not have much use for industry, they do not have substantial utility for industry, they also need to be protected, because society cannot progress without good books, good art, good lectures, good books. You cannot have progress in society only by having patents and trademarks. This is a very important concept. What do you protect in copyright? Idea को protect करते हैं या expression को protect करते हैं? So the idea can never be protected actually. You can only protect the expression. Now, supposing Dr. Pooja and I have studied the same book, but her manner of teaching in class will be very different from mine. So the book is the idea. And the way she teaches in class, the way I teach in class, my pedagogy, her teaching style, that is the expression. So Ramayana is the same, but the way I present Ramayana may be very different from the way somebody else has presented it. Just because somebody else has written a book on Ramayana or presented a play on Ramayana does not preclude me from doing so, as long as the expression is my own. Obviously, Sugriv will remain Sugriv, Ramji will remain Ramji, Sitaji will remain Sitaji. Their names will not be changed. Those are characters. Characters are part of the idea. Okay, this is the fundamental. The heart is the idea and the expression. So people who understand this problem, people who do not, they kind of struggle. One particular play has been made. Somebody wants to write a book on it. One particular book has been written, somebody wants to make a movie on it. Have we all read this thing, 5 Point Someone, Chetan Bhagat? Then the movie Three Idiots. So the whole issue is, or that this thing, movie Two States, and then the book by Chetan Bhagat, Two States. These are all adaptations. So so adaptation means you are changing the form. Even when you're doing that, you need the permission of the author or the owner of the copyright, as the case may be. You cannot do it on your own. Even for a translation, let's say Dr. Pooja or Professor Jaina have written a book in English, and I wish to translate it into Hindi. I cannot do so without their consent. Yes, in the translated work, I will have a copyright. But in order to create the translated work, I need to have the consent of the original author. Again, certain things can be transferred, certain things cannot. For example, when you write a book, publish it, most of the times, I'm saying most of the times, almost all of the times, the publisher will contain the economic rights over the book. So which means the publisher will have the right to earn royalty and so on and so forth. But moral rights. So there is a concept of moral and economic rights. Moral rights, I have a right to be identified as the creator of that work. So that is where the concept comes from, paternity. Your father always has a right over you. So I have a right to be identified as the author of that book, even though I have sold my rights in that book to the publisher or to some third party. I am the paternal rights are with me. Number two, no one can damage or mutilate the work to the best to show my work in a poor light. Now, these are very tricky questions. You may make a spoof or a parody. So these are important questions in copyright law. हमने parody बना दी. So there was a very classic case. I, as a law student, was sad that it did not go to court. It reached an out-of-court settlement. Otherwise, a new law would have emerged on this aspect. There was a movie in the 80s called Rudali. Rudali, Hindi movie. Dimple Kapadia was there. There was a scene in which it was raining hard. It was night time. It was raining hard. It was a Fiat car with a hand gear. वो हाथ से जो gear लगता था. Not the present day floor gears, hand gear. And the car is not starting. And the song starts, Dil hoon kare, sharmaye ghabraye, so on and so forth. There was, in the late 90s or early 2000s, there was a person called Sajid Khan who used to do a show on a channel called MTV. Usko wo hamming कहता था. He used to poke fun at film scenes and this and that, you know. I mean, various film scenes, movie scenes. So he played this and then he says, अब ये दिल है या Fiat car जो start ही नहीं हो रहा, हूँ कर रहा है. He thought he was poking fun. The makers of Rudali thought that they were showing Rudali in a poor light. So they sued him. And then, of course, the matter was settled outside of court. In foreign jurisdictions, this is just not allowed. I will give you an example in neighboring Sri Lanka. Sri Lanka is in the news for all the wrong reasons. If you have ever heard, and if you have not, we can just go on to YouTube and see. It's a 3-minute long national anthem. You may not understand the words because it is Sinhalese and Tamil. But the tune you will immediately recognize. The tune is Ravindra Sangeet. It is no accident because the maker of the national anthem spent all his life in Shantiniketan learning from Tagore. So the tune is Ravindra Sangeet. Now, at the request of the Sri Lankan government, when they attained independence more or less the same time as us, at the request of the Sri Lankan government, he wrote a song. The song goes Namo Namo Mata. That's the name. Just like our song, our national anthem is Jan Gan Man, theirs is Namo Namo Mata, nation as the motherland. So in the 60s or late 50s, the political party which was running the country changed. And they wanted to, started appearing in the newspapers that they wanted to change one word in the national anthem. And this man said, no, I will not allow this. I will not allow this one word to be changed because this is changing the entire meaning of the song. And I am the creator of the song. I assert my moral rights. The government said you have already been compensated for it. You wrote it at our request. We have paid you whatever we had to, and now it is our song. He says, if you will change it, you give me my song back, take the money back. The government refused. This man killed himself by slitting his throat. And he left a note which says that this is what you have done to my song. You have severed the head from the body, and this is what I am doing to myself. Now that the song is gone, I am going to sever the head from my body. So this is how tricky the issue is. So courts in India have decided that there are several cases here. The Gyan Bhavan in Delhi, the author, the person who created a mural, he found that his mural was dismantled and kept in the storeroom. Even that case he won after 17, 18 years. So courts in India have taken the stand that whether it is derogatory or not, that question has to be decided by whom? The author. कौन डिसाइड करेगा? The author. That आपने मेरे song को या मेरे work को poor light में दिखाया. So that these are the issues. So economic rights everybody understands, but moral rights I thought I will just let you know. So copyright is a body of exclusive rights. It allows you to do various things. Translation कर लीजिए, उसको जो है rebroadcast कर लीजिए, various things. There are 6-7 of them which are allowed in section 14 of our copyright law. What is copyright really? It is a protection. It is a exclusive right which is granted to the author. And once the author wants, he can sell it or transfer it to somebody else. That other person becomes the owner. So the author may be the owner, or the author and owner may be two different persons. Okay. So now we will come to what author is a little later, because we understand the word author as author of a book. Copyright law में थोड़ा सा ज़्यादा wide meaning है. So, so the purpose of copyright is to give stimuli for new inventions, new books, new plays, new music. Because otherwise, what is the motivation? Why should I work hard and share it with you? Why should I not just write it and keep it for myself? Okay. So the motivation that either you're getting the name, fame, money, recognition, that is the reason why people come and create these things. Now the inventor will want to get very high royalty, the creator or the author. Society will want to give no royalty. हमें तो सब चीज फ्री चाहिए. हम तो song भी download कर लेते हैं, कुछ नहीं देना, and we will take a book and get it photocopied. Every law tries to balance the interests of competing sections of society. So does copyright law. We try to balance the interests of both the author and the society. Now, different jurisdictions have different policies. In countries like ours, our regime may be slightly more liberal than the advanced countries. Advanced countries, Australia, US, etc., the copyright regime is very strict. Even for 5th standards, writing an assignment, they have to do a plagiarism check. So that culture is now doing plagiarism check, dissertations and so on. Previously, we were not. It is intangible property. You cannot touch and feel it. I've already told you it is non-industrial in nature. So now you can have protection for a fixed period. In India, so TRIPS mandates that minimum standard of protection is life plus 60. What do you mean by life plus 60? For most things, life plus 60. अलग-अलग चीजों के लिए अलग-अलग होता है. For example, के लिए 25 साल होता है. So 25 years from the date the photograph is taken, or 25 years from the date the photograph comes into public domain. Life plus 60 मतलब क्या होता है? So the author has died in 1960. 1961 say 60 years count kariye. So it will be public from 2021. Supposing there are two authors. The last author when he dies, 60 years from the next year. Supposing there are three authors. The last author when he dies or she dies, after that 60 years. Supposing one person died in 1958, one in 1960, and one in 1970. We will count 60 years from 1971. That means the work will be copyright protected if it is a book in India till 2000. Different works, movies के लिए अलग rules है, books के लिए, but for most things in India it is life plus 60. So what is the subject matter of copyright? Books, computer programs, plays, movies. So that is what it is. Music, LDMA, literary, dramatic, musical and artistic works, LDMA. So you are given an exclusive right to make copies. आप चाहे उसकी कितनी भी कॉपी कर लीजिए as the owner, and you can distribute it and do whatever. This copyright is protected across the world, not just in India, across the world. The first convention on this happened way back in 1886, Bern, Switzerland. 1886 Bern Convention. It has been amended from time to time because technology changed. Printing press आ गई तो फिर Bern Convention की जरूरत पड़ी. Tape recorder आ गया तो 1961 में Rome Convention की जरूरत पड़ी. Phonograms आ गए, recording facilities आ गए. Satellite convention, so on and so forth. The most recent amendment has happened in TRIPS 1994. I have given you the website address of the Copyright Office in India. This is under the Ministry of Education, copyright.gov.in. It also has for online registration.
Sir,
आपको कुछ भी register.
Sir,
Yes,
sorry to interrupt, but to me the slides are not moving.
No, they're not moving, ma'am. I'm on the last
Okay.
line of this page, which is copyright. It's not moving. Thank you.
Okay.
So the website of the Copyright Office, copyright.gov.in. This office functions under the Ministry of Education. And if you wish to get anything copyrighted, just pay the online fee. The fee depends on the length of your document. It might be 400 rupees or 4,000 rupees, something like that. And you upload the soft copy of your document, you will get the copyright registration. There is no formality, there is no need to hire a lawyer. There are simple forms like we fill up, something like our Google Forms. So this can be done, and I encourage all colleagues to get their works copyrighted. So if you are writing a thesis or a dissertation or something like that, it is a good idea to get it copyrighted. If you're writing a paper for a journal, obviously the journal is going to have the copyright, so there is no point. But if you are writing for a book, the book will have the copyright. So, but if you are writing something of your own, for example, a thesis or something like that, then it is a good idea. Or even you have your own blog page and all, good idea to have it copyright protected. So I talked about author and owner. So author is the person who has created the work, जिसने वो बनाया है. Definition of author is very important. So in the case of music, the composer, music director is the author. Why? Because he has got all the people together: the singer, the lyricist, the the fellow who plays the sitar, the chorus. उनको सबको वो एक साथ लेके आया है, तो उसको दिया जाता है. In the song, movie mein, the producer of the movie is the author, because he has he has hired all these people, the cast, the director, all of these people. In the song, the author is the lyricist who has written the lyrics of the song. So जब भी आप देखते हैं कोई song अगर टीवी पे आता है, उसमें लिखते हैं lyrics by so and so, the music composer so and so. Music composer last में होता है. The lyrics by so and so, the singer is so and so on and so forth. The owner is the person who has control. The owner is the person जिसका वो work है. The owner and author may be the same person, or the author may have given the owner the rights to exploit the work commercially. Author is always the first owner. This is what has been laid down by the Supreme Court in Chiranjit Singh versus Dua brothers. Always. So if Dr. Pooja were to write a book and go to, let's say, Thomson Publishers, so she is the first owner. Thomson will become the second. Thomson decides to allow John Wiley Publishers to sell the work in USA. John Wiley will become the third. That is how it works. So the ownership is different, and you may have a copy of the book. That doesn't mean you are the owner of the book. मैंने ये किताब खरीदी है from the market. That doesn't mean that I am the owner of the copyright in the book. The owner of the copyright of the book in this book is the publisher. I have the right over this particular copy. Does that mean that I can start selling this book? The answer is no. मैं इस book की photocopy बना के नहीं बेच सकता. There has been a very landmark case in the Delhi High Court involving Delhi University, Rameshwari photocopy. So there was a photocopy shop which was making course packs in Delhi University, and the three major publishers took the photocopy shop and the university, because the photocopy shop was functioning in the university, to court. So very landmark. ये आप नहीं कर सकते. You cannot, completely photocopy the books. Yes, course packs can be made. 10 pages from this book, 10 pages from this book, that can be done. So the ownership of copyright in our law is dealt with in section 17. Now, what happens when you have protection? So literary, dramatic, musical, artistic works, photograph, cinematography, which means films, these are the things which are coming within the subject matter. Unlike other things, for example, trademark, you have studied designs, you have studied geographical indications. Aapki protection starts only and only when you have already got registration. Until you have, if you have not protection which you will get for your work, there is absolutely zero protection that you will get for your work until you have got it registered. So registration is what gives you the rights. Copyright mein aisa nahi hai. Copyright is created the moment the work is fixed. Fixed means written. Fixed is just a technical term, written on any medium, soft copy or hard copy. मैंने अपने कंप्यूटर में कुछ टाइप कर लिया, मैंने पेपर पे कुछ लिख दिया, copyright is immediately created. If it is in mind, there is no copyright. Nobody can sit in your mind and see X-ray. So different countries have different kinds of copyright is there is no mandatory requirement for registration, but why do we suggest go for registration? It is easier to prove in the event of a dispute. So हम लोग घर की लीज करते हैं, घर लेते हैं रेंट पे. कई लोग तो agreement करते ही नहीं. Some people write an agreement. Some people get the agreement registered. It is easy. Similarly, a will. You can die without making a will. You can make a will on any plain paper, or you can go to court and get it registered. In the event of a dispute, a registered document will always help you as compared to an unregistered one. That is why we are saying go for registration. Especially when it costs nothing and there is no procedural formality as such. So different countries have different standards of protection. Friends, Berne Convention came in 1886. The largest country in the world with the maximum amount of copyright, the United States, did not join the Berne Convention for 100 years until 1987, because they feared that their own domestic copyright laws will be diluted by the Berne Convention, because Berne was at that time providing protection only for 70 years. Minimum protection requirement was 70 years. US was providing protection for minimum 100 years after the death of the author. So इन्होंने join ही नहीं किया, बोला कि हम join करेंगे तो हमारे standard खराब हो जाएंगे. So for 100 years they did not. US also is the only country in the world जहाँ constitution में लिखा हुआ है copyright protection. Today US has brought it down to life plus 70 for most things. Like in India, for most things it is life plus 60. For some things, even today in US, it is life plus 100. TRIPS says life plus 60 for most things. So, अब हम थोड़ी सी बात करेंगे plagiarism की. Plagiarism is misconduct. It is very serious. Very, very senior people, vice chancellors. There is nobody higher than that in the university system. Vice chancellors in public universities, private universities have lost their jobs. People have gone to jail in India for this. कभी भी plagiarize मत करिए, कुछ भी मत करिए. ये नीचे जो मैंने केस का नाम लिखा है, फतेह सिंह मेहता वर्सेस स्टेट ऑफ राजस्थान. This is a case wherein a PhD supervisor who was asked to correct or asked to guide the candidate, he went and published the candidate's work in the form of a book in his name. The candidate was able to win the case. Why? Because she was corresponding with him through this thing, registered post. आज के जमाने में registered post नहीं है, email है. My sincere advice to all of us who are not already completed PhDs or even those who are guiding PhDs, please ensure that whatever work you are checking, it should always come via email, not on printout, not on pen drive. उससे क्या होता है? It is very clear that किस date को उसने आपको भेजा, and is it your work or is it his work? Because whatever comes on email is automatically time-stamped. So this is a good way, a practical suggestion that what I would advise people. I do that with my scholars. So whatever, in fact, nowadays it has become so easy. You meet them on Google Meet, and so that even that the thing is there. So just a suggestion. You may have your own ways of doing things. So this is what PM Bakshi says in Iyer's Judicial Dictionary. You are appropriating the literary composition of somebody else. Now, there are different ways of plagiarizing. Somebody will do a literal copy. Somebody will do what is called paraphrasing. आजकल इंटरनेट पे आर्टिफिशियल इंटेलिजेंस टूल्स आ गए. वो आप डालेंगे, कुछ उस पर टाइप करेंगे, इट विल गिव यू द सेम आइडिया, सेम थिंग इन डिफरेंट वर्ड्स, बट इट विल ऑल बी कॉट. Please don't do this. Okay, so even if your words are different, it will still be caught because the anti-plagiarism softwares are now trained to do this. So you are passing this off as your own. This is PM Bakshi's definition. Clark says wrongful appropriation, close imitation, purloining, matlab chori karna, publication of thoughts or ideas or expression or representation or all of them and showing it as your work. So this is the history of plagiarism. Encyclopedia Britannica says plagiarism is derived from the Latin word plagiarius, which is a kidnapper, a stealer, an abductor. The Oxford Dictionary says it is actually kidnapping in Greek. This word has first been used in the 17th century. And by the middle of the 18th century, it has become rather common in the West. In advanced jurisdictions, plagiarism has become rather common. In India, by the end of the 20th century, it has been rather common. And in the 21st century, absolutely in your face. So, what constitutes plagiarism? It is not necessary कि आपने exactly word for word किया है. If you have lifted a substantial portion, even that is plagiarism. I will talk more about substantial portion. Exact counterpart. See, somebody will say, sir, 10%, 20%, 30%. There is no cut and dry formula. Maybe in some work, the central theme is written only in 2 pages or in half a page. The entire book is 300 pages. आपने 3 पेज उठाए हैं, 2 पेज उठाए हैं 300 में से. It is not even 1%, but you have lifted the central theme. Courts will say it is substantial portion. On the other hand, if it is something peripheral, you may have lifted 30 out of 300, 10%. Courts will be tending to ignore it. So not just quantity, also quality. What is being lifted, what is being copied, the quantity and the quality are both important. So exact counterpart nahi hona chahiye, and aisa bhi nahi ki words change kar diye, because it is not just the words, it is the thoughts and ideas also. So now we are just talking about some commons, because when we talk about copyright, these are the copyright licenses in which the author has waived off certain rights. Creative Commons, for example, Wikipedia functions under a Creative Commons license. Wikipedia, you can, of course, please don't quote Wikipedia when you're writing your thesis or your books or whatever, because Wikipedia is, you can quote the sources जहां से Wikipedia ने लिया है, but Wikipedia पे लिखा हुआ है वो बिल्कुल मत करिए. कुछ लोग करते हैं, हमारे स्टूडेंट्स करते हैं, उनको फिर समझाना पड़ता है why it is not done. Situation has changed. 10 years ago, Wikipedia was giving limited access to edit. Today, any ordinary person can edit Wikipedia. 10 years ago, till 2013, access to only subject matter experts. Who decided who was a subject matter expert? They themselves. So, for example, if it is an article on forensics, somebody who is a big forensics lawyer or a forensic science doctor or somebody who's working in a forensic science laboratory or somebody like that would have access to that page. Create it, edit it, whatever. Today, anybody can do it. So if a lay person, so they have done it intentionally. They are now operating under a Creative Commons license, which allows anybody, works on a principle of sharing. Anybody can put information, anybody can take away information. इसके पीछे लॉजिक वही है, जैसे आपने देखा होगा शहरों में होती है नेकी की दीवार. आपके पास जो एक्स्ट्रा सामान है वहां रख दीजिए और जो आपको जरूरत है वो वहां से ले लीजिए. So that is the principle behind the Creative Commons licensing. It is non-profit in nature and it wants to have educational access given to various people. So you can legally use it for sharing. Creative Commons licenses are issued and authors can communicate with each other. They are waiving of their rights. The explanation, etc., is very simple. And so usi cheez ka, you can also come out with a regular version and there you can assert your copyright. So for example, I may create a page on Wikipedia about my book, Interface of Design Law with Copyrights Law, Trademark Law. There, when I'm creating that page, it is under a Creative Commons license. I am waiving off my rights. The same thing when I'm explaining in greater detail, I am asserting my copyright. So that is allowed. So one such organization which is functioning under Creative Commons, such license is CC, Creative Commons. I've given the website, given the logo. This was founded in 2001. एंड ये पिछले 20 साल में ज्यादा शुरू हुआ है क्रिएटिव कॉमन्स. अब ये सॉफ्टवेयर के एरिया में भी आ गया. सो लाइक यू हैव माइक्रोसॉफ्ट ऑफिस wherein you pay for it, right? Licensed version for Microsoft Office, you pay for it. Word, Office, PowerPoint, everything is there. Pirated versions are there. And then there is an open version called Open Office. उसका लोगो ओपन ऑफिस वर्ड का लोगो MS वर्ड के लोगो से मिलता जुलता है, बट सेम नहीं. So that is the position. And so in the last 20 years, lot of work has happened in this. And Wikipedia, I told you, is functioning in this. They have moved over to Creative Commons in 2013. So moral rights, जो मैंने आपको पहले बताए थे, this concept started in France. Copyright law actually start ही फ्रांस में हुआ. There was a person called Victor Hugo. उसका मूवमेंट था, वहां स्टार्ट हुआ ये. कॉपीराइट लॉ स्टार्टेड देयर एंड ट्रेडमार्क लॉ स्टार्टेड इन इंग्लैंड बिकॉज द इंडस्ट्रियल रेवोल्यूशन हैपेंड इन इंग्लैंड. आई विल टॉक मोर व्हेन आई कम टू ट्रेडमार्क. सो फ्रांस, जर्मनी, इटली में मॉरल राइट्स की बहुत ज्यादा वैल्यू है. कोपिंजर इज अ वेरी फेमस अथॉरिटी इन कॉपीराइट लॉ. ही सेज दीज आर पर्सनल राइट्स, नॉट कमर्शियल राइट्स. दैट इज व्हाट कोपिंजर सेज. आर्टिकल 6 BIS ऑफ द बर्न कन्वेंशन, जैसे हम आज की डेट में रोमन लेटर्स कहते हैं, ये लैटिन में ये लेटर्स हुआ करते थे. 6 bis, इट सेज राइट टू क्लेम ऑथरशिप and object to distortion, mutilation, etc. जो मैंने आपको बताया. These rights remain with the author even after the economic rights have been given away, transferred. Under the Berne Convention, these rights are there. Under the most recent TRIPS, they are there. Now coming to trademark. Now see, पहले जो है goods used to be made by hand. Whether it is a shoe, whether it is a brush, whether it is a watch, whether it is bread box, सब कुछ हाथ से बनता था. Most of the things were made by wood, rubber, whatever. So every creator, every craftsman would put his own signature, would put his own mark on them. जैसे आज की डेट में आप पेंटिंग्स में देखते हैं हुसैन, गुजराल, ऐसे ही इन सब पे हुआ करता था. So in India also we were shipping the goods as far as Iran. Mind you, there was no Suez Canal. So from India, when we were sending the goods, even 100 years ago to Europe, 6, 7, 8, 9 महीने लगते थे, depending on where in Europe. So the goods had to travel long distance and we were doing it. So Middle Ages में trade बहुत flourish करने लगा. So to distinguish, people started putting their signatures. But इसकी economic significance नहीं होती थी. It was just to tell people हाँ कि इसने बताया. This is the source of goods. Now things changed after the Industrial Revolution, 1857, middle of the 19th century. Industrial Revolution started in Britain, UK. Goods were now mass produced. Mass produced goods का मतलब क्या होता है? सब एक जैसी लगती है. It's like when you go for an interview, when you go to take an interview or to give an interview, especially the men, आपने देखा होगा सारे एक जैसे लगते हैं. व्हाइट कलर की शर्ट पहन के आएंगे, कॉन्ट्रास्टिंग टाई पहन के आएंगे, ब्लेजर पहन के आएंगे. There is no individuality. They've cut their hair short, they've shaved, they all look the same, right? Black color shoes, polished, right? Otherwise they don't. So similarly, after Industrial Revolution, the goods began to look the same. अब आप distinguish कैसे करेंगे? There is now a need to create artificial differences to give your mark special identification. Go back to what you have studied in your physics class, friends, 8th or 9th standard. Soap, साबुन कैसे function करता है? I will just refresh your memory. साबुन के दो ends होते हैं. एक हाइड्रोफोबिक होता है, एक हाइड्रोफिलिक होता है. हाइड्रोफोबिक does not like water. Haydrophilic likes water. एक end attaches itself to the dirt. The hydrophobic end attaches itself to the dirt. The hydrophilic end attaches itself to the water. When you rub the soap on the dirty part, whether it is your hand or the cloth which you are washing, every soap, whether it is washing soap or bathing soap or face soap, works the same way. The part which is the soap which is there on your hand will attach, the one end of it will attach to the dirt and the other end to the water, and that is how your hands will become clean. Now this is not every soap does this. अब आप इसको अलग कैसे करेंगे? So that is how you have created artificial differences. ये Lux है, ये Pears है, ये Ariel है, and so on and so forth. How? By saying इसमें detergent, इसमें जो है caustic soda ज़्यादा है, इसमें moisturizer ज़्यादा है, इसको advertise करता है जूही चावला, इसको advertise करता है so and so. The brand positioning, the pricing, the packaging, these are all the artificial differences. So that is, I'm giving you one example. You can find hundreds of other examples. Take the shape of this bottle of water. You see this bottle? You have studied in the design law class. This shape is not required to be given. It can be cylindrical also. But ये shape क्यों दिया? Because Tupperware wants that their product should be distinguished from others. Take the example of this box. They have given these blisters. What is the need to do that? They have just given that for the artificial differences, कि दूसरों से अलग कर सके. So that is the whole purpose when there are mass-produced goods. Now, what is a trademark? It is a sign. It is a mark. Trademark is a mark used in trade. Is every mark a trademark? The answer is no. Is every trademark a mark? The answer is yes. We may have all played this game in our childhood, Raja Mantri Chor Sipahi. Yes or no? So Raja Mantri Chor Sipahi, when we were playing, we would try and put an identification mark on the Mantri ka chit, the Chor ka chit, pick up one chit or avoid picking up one chit. That is a mark. We are in our notebooks, we are writing our name. That is a mark. But are we selling our notes? Are we selling those chits that we have made? The answer is no. But we are selling this Microsoft mouse. This Microsoft mouse we are selling. So that is why this Microsoft mouse, when it says Microsoft, it is a trademark. It is a sign which individualizes goods and it is distinguishing them from others. WIPO says it is a sign which identifies goods or services. So in India, ये जो पहले था 2003 के पहले, services were not under the trademark law. But today, even services, financial service, banking service, education service, they are all part of the trademark law. So K.R. Mangalam, it's a trademark. The logo that you are using behind you, it's a trademark. Right? So these are all, so it is by which you are identifying a specific person, specific enterprise. Our trademark law 1999, which came into effect from 15 September 2003. Okay, after TRIPS, all our IPR laws have had to be changed to be in conformity with TRIPS. Not only ours, every country's. So the developed countries were given time from 96 to 2000. The developing were given time from 2001 to 2005. And the underdeveloped or third world countries, like most African countries, Bangladesh, etc., they were given time from 2006 to 2010 to bring their laws in conformity with TRIPS. So, आप इंडिया में देखेंगे, all the IP laws are either newly created or completely amended in the period between 2001 to 2005. Patents 2005, trademarks, new law 2003, GI 2002, designs 2002, semiconductors 2003. So all the laws have been created during this period. So this Trademarks Act 1999 says that it is any mark capable of being represented graphically. मतलब उसको हम print कर सकते हैं. Of one person from those of others. So it should be capable of distinguishing the goods and it should be capable of being represented graphically. मतलब capable of being shown on any paper or cloth or whatever. It includes shape of goods, packaging, combination of colors. Because of this definition, we in India cannot recognize smell marks and color marks. We have intentionally done so because our population is by and large illiterate. So they may not be able to understand this, and the trademark will not be able to serve the basic purpose of distinguishing between the goods. I will share with you one of the biggest florists, फूल बेचने वाला company in India, in USA, I'm sorry. Do you know what is their trademark? It is an olfactory mark. It is a smell mark. It is the smell of rotten eggs. Yes, hydrogen sulfide. वो उनका ट्रेडमार्क है. तो जो बंदा लेके आता है वो जो है सडनली एक बल्ब प्रेस कर देता है, हाइड्रोजन सल्फाइड इज रिलीज्ड, द स्मेल ऑफ रॉटन एग्स इज देयर एंड दैट इज द ट्रेडमार्क ऑफ द फ्लोरिस्ट कंपनी. ओके, इन जर्मनी दैट इज द फर्स्ट कंट्री टू रिकॉग्नाइज कलर मार्क्स. एशियन पेंट्स के ऐड में नहीं आता मेरा वाला पीच, मेरा वाला पिंक. I don't see TV nowadays, so ये सब मैं जो चीजें एग्जांपल बता रहा हूँ 20 साल पुराने 15 साल पुराने. So जो है that मेरा वाला pink you can register in Germany, lot of other countries, not in India. We do not recognize single color marks. Yes, combination of colors, yes. So Pizza Hut, black and red. Domino's, black and blue, yes. Without Domino's or Pizza Hut written, अगर ये दोनों color है वो भी हम recognize करते हैं. But single color mark, no. So एक ट्रेडमार्क के दो एस्पेक्ट्स या दो फंक्शंस होते हैं. It gives you information about source of goods and something which we generally gloss over. It protects the interest of the consumer. How? I know OnePlus makes very good phones. I buy a phone which is OnePlus, and that is what gives me the OnePlus phone is. I mean, I'm buying it because it gives me certain assurance of quality. I buy a Kelvinator fridge. I buy an LG AC. I go to XYZ University, which I think is very good. All of these are protecting the consumer. So, OnePlus's name and making phones which are not good quality, you are cheating the consumer. You are spoiling the image of OnePlus. So, both the dimensions have to be seen. So now, what are the characteristics of a trademark? So, or the need to protect a trademark. So, brand image kharab hogi agar if we do not protect a trademark, because customer will go to Patala House Courts. All the cold drinks which are sold to you are spurious, nakli. You go to North Campus, where my university is located. All the cigarettes that are sold are spurious. Gold flake is not gold flake, and classic is not classic, and gold spot is not gold spot. So who's losing? The company is losing. Most people will say, "Arey, to company duplicate maal bech rahi." So this is the problem. The customer gets deceived because he thinks that he is getting a good quality product, but he is not. Sometimes there is very close similarity, deceptive similarity. Bisleri hoga और बिलसेरी लिखा होगा. You have heard of बिस्लेरी, but बिलसेरी आप खरीद लेंगे बिस्लेरी समझ के. नेस्कैफे की जगह नेक्सफे हो जाएगा. One letter here and there. Transposition. Science shows that if the number of letters is the same, the first and last alphabet are the same, your eyes are trained to look at it. You will gloss over it. Nescafe, 7 letters. The moment your eyes see 7 letters, the first being N and the last being E, you will read it as Nescafe. So if they have transposed C and S and Nescafe, you will still read it as Nescafe. That is why you have this brand called FCUK. If they write the correct spelling, it will not be allowed as per law, because you are using something which is profane. You cannot. It is not allowed by law. But you are using this because the eyes are going to read FCUK as whatever. So because the first and the last letter. So deceptive similarity. Yeah, Slimline is a cistern brand. There is in the news yesterday I was reading, there is somebody who's making Seamline, SEEMLINE. So these are the things which that is why we need to protect our trademark. The characteristics of a trademark. So they should be used, like I said, during trade. They could relate to either goods or services. Previously, in the old Act, 1958 Trademark Act, which was in force up to 2003 September, we were recognizing 34 classes of trademarks. No this thing, services, only goods. Today we recognize 6 classes of goods and 8 classes of services. So they should be able to indicate the source of goods. They should be able to distinguish the goods of one from others. बहुत पास नाम नहीं होने चाहिए. एक को mistake कर लें आप दूसरे के लिए, ऐसा नहीं हो. It should be used for the purpose of indicating the comparison, the connection. They can be in the form of a shape mark. So a lot of, in fact, a lot of the present day trademarks, आजकल कोई trademark ऐसा जैसे पहले होते थे ना, vanilla trademarks, just the text, Microsoft written, ऐसा कोई trademark आज की डेट में नहीं होता. Microsoft in a particular font, along with a particular logo, in a particular color. That many times it is also in the form of a shape mark, the goods itself. So Apple and Samsung, they keep fighting every few years. Phone ke design ka jo hai, that becomes a shape. That is also the subject matter of trademark. I just gave you the example of this Tupperware bottle. This is a shape. See, this is a shape. This is not a cylinder, it tapers. Okay. I will give you another example. This is a Schaefer pen. See this? This is a Schaefer pen. There is a white dot. This white dot is only there for shape, for show. इसका कोई मतलब नहीं है. नहीं होता तो क्या फर्क पड़ता? कोई फर्क नहीं पड़ता. It has no functional utility. So copyright, I told you, life plus 60 is the normal thing in India. Trademark can be enjoyed in perpetuity, friends. There are some trademarks in Britain which have now been in existence for 150 plus years. 150 साल हो गए. For example, Dunlop. So you can in India you can get a trademark for 10 years. 10 साल के बाद फिर फीस दे दीजिए, फिर 10 साल हो गए, फिर फीस दे दीजिए, फिर 10 साल. You can enjoy it in perpetuity. So you can keep enjoying. Similarly, GI you can enjoy in perpetuity. The others you can't. Design is 10 plus 5 in India. So you can now, how can you protect a trademark? We have seen in the case of copyright, the first international convention is actually the Berne Convention, 1886. And the first convention here is, it is misprinted, it is 1883, Paris Convention. Paris Convention on Industrial Property. Paris, so this is the first industrial property to be protected. So Paris Convention is the first one which was there, and the countries decided that they will start respecting others' trademarks. And you can either protect it on the basis of use or registration. Now, what does this mean? Some of us are born great and some acquire greatness to our hard work. So this is what some are. So Sachin Tendulkar was born great. Rahul Dravid became great over time, right? So what needs to be seen is on the date you are going for registration, are you distinctive? You meaning the trademark. Is it distinctive? If the answer is yes, you will get the registration. If the answer is no, you will not. So if you have not, if the answer is no today, doesn't mean the answer will be no 5 years later. So I hope I'm making myself clear. If the answer is no today, the answer will not be no 5 years later also. It is possible that in the 5 years wherein you are working as an unregistered trademark, you have been able to build up so much reputation for yourself that you are able to distinguish yourself. So it becomes, you have acquired that distinctiveness. Or it could be that you have come up with such a different name. So decathlon, ketchup, ये इतने distinctive नाम हैं कि वो git pit इतने distinctive से नाम हैं, nobody has thought of them, so they will immediately get registration. On the other hand, there may be certain names which may have to work hard and prove their ability to distinctive. So be distinctive, maybe 3 years, 5 years, and so on and so forth. So both of these approaches have their place under the sun. Both Rahul Dravid and Tendulkar played for India. So the use, which means acquired distinctiveness, plays an important role in countries which like ours, जो hard work पे importance ज़्यादा देती है. So this approach of acquired distinctiveness is also there. It has more importance, I would say. And if you want to look at the forms and fees, etc., this is the website, ipindia.gov.in. So this is the website. It has all the various forms, TM1 form for registration, TMO, TMR for rectification, TMO for objection, agar aapko lagana hai, so on and so forth. This website is there. The IP office, which controls patents, designs, trademarks, it functions under the Commerce Ministry. Unlike copyright, functions under the Education Ministry. So now this thing, how do you go ahead and protect it? So the first user has priority, not the one who has first registered the mark. ये बड़ा important हो जाता है. कई बार लोग जाके mark, again courts have to balance. Many a times, see, nowadays it is not as if your business is limited to India only. So there are lots of foreign marks also, and there are lots of Indian marks. So if somebody has a foreign mark and is not intending to sell the product in India at all, then should we be giving protection to that fellow? Those are the questions before the court. And so the priority in India is given to the one who is first using the trademark, not somebody who has first registered the trademark. And this is also the approach which US follows, UK follows, Philippines, Indonesia, all basically common law countries, Malaysia, Pakistan, Australia, we are all following the same approach. On the other hand, in civil law countries, maybe France, Germany, they follow the approach that जिसने पहले register कर लिया उसको पहले सुनेंगे. So that is what we are doing. Everybody follows trademark protection today. Everybody in the world, except for some people like Bhutan and Maldives, जो trademarks का concept recognize करते ही नहीं. उनके यहाँ ज़्यादा manufacturing है ही नहीं. So for example, in Bhutan there is no manufacturing. Everything is either from India or from China. Same is the case with Maldives. So that is the reason they do not feel the need to have the system of trademarks at all. They are basically countries जहाँ पे अभी भी सब कुछ handmade है, right? चीज भी handmade है, तेल भी handmade है. तो handmade वाले में तो वो आज भी वही काम कर रहे हैं जो लोग 3000 साल पहले अपना हाथ से लोगो बना देते थे, symbol बना देते थे. Friends, there is the approaches are different. Courts have taken different approaches for trademark depending upon the kind of product. So how strict the court will be depends upon what product it is. I will just give you an example. Supposing the product is BD, or supposing the product is chewing tobacco, which is consumed by rickshawalas and uneducated people, the code will be very strict. The code is going to be very, very strict in those cases because the chances of deceiving such people will be very high. The propensity to deceive such people is going to be very, because they are not very educated. I will give you an example. The name of the case is Muhammad Iqbal versus Muhammad Wasim. And here, there was one fellow whose trademark was Pawara, written in Hindi and Urdu. And there is another fellow whose trademark was the fountain. मतलब fountain बना हुआ था, fountain की picture बनी थी, कुछ लिखा नहीं था. The court disallowed. Why? Because the basic idea that is conveyed by both the marks is the same. एक में फव्वारा का फोटो बना हुआ है और एक में फव्वारा हिंदी और उर्दू में लिखा हुआ है. And the product is BDs, which are sold in a bundle costing a few rupees, consumed by labor class. Again, I'll give you another example. The similarity may be visual, the similarity may be phonetic. So phonetic similarity is very important as well. Lot of business today is carried out on the phone. Again, there is a case of chewing tobacco, snuff. The two marks are Sri Ambal and Sri Andal. Now they are both Ambal and Andal are both different goddesses. One of them is Parvati ji's name, and one of them is a patron saint in Sri Valluvar in Karnataka. इंडिया में भगवानों की कोई कमी तो है नहीं. सो दो अगर भगवान दिखाए हुए हैं तो ऐसा तो है नहीं कि आप उससे डिस्टिंग्विश हो जाएंगे. There are even goddess Durga, you know, she has 108 names. Goddess Durga, 108 names. There are God knows how many Bhagwans. Everybody has their own Kuldevta. There are people who are non-Hindus. There are people who are atheists. There are people who may not recognize gods and goddesses. Ambal, A-M-B-A-L, and Andal, A-N-D-A-L. Court says no. Phonetic similarity बहुत ज़्यादा है. Not allowed. जो पहले register हो गया वही वाला चलेगा, दूसरा वाला नहीं चलेगा. So it depends on various factors that what is the overall impression conveyed, how much time is taken to arrive at the buying decision. If it is a product rich people, expensive product, the court will be more liberal. But if it is a cheap product where you don't spend much time in making the buying decision, where the consumers are illiterate people, the court will be very strict. And do you know where the court will be most strict? The court will be most strict in the case of medicines, because drugs are poison, not sweets. I'm quoting from a court judgment, Cadilla versus Cadilla. Now, in this case, both these drugs are drugs of the last resort. What is drugs of the last resort? इसके बाद कुछ हो नहीं सकता. So there are two drugs. Both the drugs, one is named Falsigo and one is named Falsitab. And the manufacturer is Cadilla. Cadilla Group split into two, just like the Reliance Group split into two when the father passed away. In the Reliance Group had split. Both got the right. ऐसे जब भी split होता है, दोनों groups के पास right होता है to retain the name of the original group. So just like both the brothers have the right to use the name Reliance, both the Cadilla groups had the right to use the name Cadilla. Both of them were active or are active even today in the pharmaceutical business. In the pharmaceutical business, there is a convention. ड्रग का नाम दो चीजों के बेसिस पर रख सकते हैं और तीसरा किसी और चीज पे भी रख सकते हैं, पर दो चीजों के बेसिस पर रख सकते हैं. एंड यही जनरली लोग करते हैं, सो दैट डॉक्टर्स, मेडिकल रिप्रेजेंटेटिव्स, केमिस्ट, दे आर ऑल अवेयर, दे कैन फिगर इट आउट. One is the name of the active ingredient and one is the name of the disease. So the name of the active ingredient and the name of the disease. So I will give you examples of both. Paracetamol. Okay, paracetamol, bukhar kam hota hai. It can be sold in the market as Parasip, Paratop, para this, para that, etc., etc. All of these are names which are there. The parasip, paratab, falana, falana, they are all derived from paracetamol. Or it can be used to on the base, it can be named on the basis of the disease. Covishield, Covaxin, COVID this, COVID tab, COVID this, COVID that, all based on COVID. So in this case, the disease was falciparum malaria, brain fever. One drug was Falcigo, the other drug was Falcitab. The company is also, I mean, the name of the brand. So it is Cadila Falcigo and Cadila Falcitab. Now the composition of the two drugs is different. When the composition is different, it means that the contraindications will also be different. किसको दे सकते हैं, किसको नहीं दे सकते, BP वाले को दे सकते हैं, शुगर वाले को नहीं दे सकते, etc., etc. In the best case, now अगर आप Falcigo prescribe किया और आपने दे दिया Falcitab, in the best case, what will happen? असर नहीं होगा. There will be no therapeutic impact. In the worst case, what will happen? The fellow is almost dead. If you give him the wrong medicine, what will happen? He'll die. So the matter went up to the Supreme Court. Supreme Court has framed rules. Supreme Court refused to decide the matter. They sent the matter back to the trial court, the district court. And they said, we have framed the rules. As per these rules, you please decide within 6 months. If you are not happy with the decision, you come in appeal again. One of the fellows who lost came in appeal. Supreme Court again decided, did not interfere with the decision of the trial court. But that is those rules have become the 8 rules which the Supreme Court has given, have been known as the Cadila rules. So they specifically say that for medicines, you have to be very careful. For other products, depend on what kind of product it is, how inexpensive, how less time, take less time, inexpensive, bought by illiterate people, poor people, you have to be more strict. But if it is medicine, maximum strictness and maximum leniency for products which are bought by the educated class, well-heeled people. I have previously talked about this thing, that brand reputation gets impacted and so on and so forth, deceptive similarity. This is a very important concept, especially in today's days. Brands, etc., have to be very conscious about what they do. Some of you may have heard about the recent controversy wherein film stars were advertising for pan masala, because film stars have impact on society, whether it is Akshay Kumar or Amir Khan or whatever else. So the controversy which is there, that is very important, because the brand will want to engage these people, but should these people be doing it? Those are all certain issues. Now I will take you through a very celebrated case, and after that I will just open it up to questions. Now 2 cases I want to discuss. One is this Welcome Group and Marlboro case, Philip Morris versus Marlboro. So Philip Morris versus ITC. Now ITC is one of the companies in India. I told you that we have 44 classes of trademarks, different classes. So class 6 is tobacco. Medicinal and toilet preparations, I think, is class 14 or something. So ऐसे करके different classes. So ITC is one of those guys who has a presence in all 44, which means all the service marks and all the goods marks. सब में है. ITC के होटल भी हैं, ITC की सिगरेट भी है, सब कुछ है. Friends, ITC does not use the same logo on the cigarette mark and the ITC on the hotels. आज की डेट में सिगरेट पीना अच्छा नहीं मानते. 70s और 80s के दशक में सिगरेट को बहुत अच्छा मानते थे. Right? These days, cigarette smokers are like lepers. I mean, I don't mean to be rude to anybody, but cigarette smoking is not considered a good thing today. So, in fact, now you see in movies also they will write that when on web series also they will write, and all of that happens. So, hotels, etc., do not let you smoke in front. They don't let you smoke in the room. They don't let you smoke in the front. Pehle, I remember when I was younger, होटल की पोर्ट्स में खड़े होकर लोग स्मोक करते थे, ट्रेन में फर्स्ट एसी में लोग स्मोक करते थे. Now you're not allowed to do that. So there are smoking zones in hotels and airports, but they are banished पीछे. So ITC का जो लोगो है उनके होटल्स पे, go to Sonar Bangla in Bengal, Calcutta, go to this one Maurya in Delhi, go to Kakatiya in Hyderabad, go to Grand Maratha in Bombay, or go to Grand Bharat in Gurgaon, Manesar. You will find उनका लोगो ऐसे करके नमस्ते वाला लोगो है, which is what they use for their hotels, which are ultimate luxury, 5-star, 7-star, whatever. On the other hand, what they use on their cigarettes is a triangle. Triangle के अंदर ITC लिखा होता है. They consciously don't use that. Now, what they are alleging is that this company Marlboro has a presence in India. पहले इनका लोगो था M लिखा हुआ. See, in the trademark, in the consumer goods business, you have to keep being fresh. You have to keep changing your logo repeatedly, otherwise customer bore हो जाएगा. So you will find Airtel ने भी अपना logo change कर दिया थोड़े दिन में. You will find everybody keeps changing their logos in the FMCG space, because FMCG space में the fight is always for the consumer's eyeballs. So the Marlboro company, they had a logo which was called Roof of the World logo. मतलब एक M जो straight था, straight M, Roof of the World, like Atlas, the entire world का weight on the M. दिवाली टाइम पे इन्होंने अपना लोगो चेंज कर दिया because they wanted to sell gift packs. It was as if the flaming M logo, उसका नाम था flaming M, which was slanting towards the right side, and it was as if it was on flames. ITC कहता this logo, the modified logo, is very close to my logo, and this is going to turn away my customers, because my customers don't want to be associated with cigarettes. I also make cigarettes, but I don't use this logo on my cigarettes. I keep the cigarette business at arm length. Incidentally, ITC का पुराना नाम Imperial Tobacco Company है. Incorporated as Imperial Tobacco Company. After independence, it became India Tobacco Company, and today it is ITC. तीन नाम रह चुके हैं उसके, दो नाम चेंज हुए हैं. पहले Imperial Tobacco Company, then India Tobacco Company, today simply ITC. Okay, legally it is only ITC today in the ROC's Registrar of Companies books. So this they have done to genuinely keep the tobacco business away. So they say that इससे मेरा नाम खराब हो रहा है. You are diluting my trademark. So the court has gone ahead and upheld it, saying that yes, आप please इनका logo थोड़ा सा अपना change कर लीजिए Marlboro. Marlboro says no, they are scared of me because they think I will eat into their cigarette business. I am new. They don't want me to start business here. So, but the court said no. You please change your logo. You are, it is possible that their hotel brand may suffer a loss, because in today's world, it is not just reality. Even perception matters. And in this world of branding, in this world of commerce, so trademark law, advertising, in सब का बहुत close relation है. You cannot, you cannot really afford to have a perception also. Even that is a problem. I will just come to my last topic of my talk, the last case which I wanted to discuss with you, which is very relevant in today's days. It is again in the FMCG space, ये बहुत ज़्यादा होता है. It is called comparative advertisement. Have we all seen that movie Gadar, Sunny Deol? Yeah. So there is a particular scene I want to talk to you about, and then I'll talk about this because then you will be able to relate very well. Sunny Deol is asked to say Pakistan Zindabad. He does it. He doesn't like it, but he does it. No problem. Next is asked to say Hindustan Murdabad. And he flies into a fit of rage and he pulls out that hand pump and he says, Ashraf Ali, तुम्हारे पास जो है बारिश होती है तो तिरपाल की जगह नहीं है, blah, blah, blah. Right? He does all of that. He flies into a fit of rage when he is asked to say Hindustan Murdabad. The same is the logic here. In trademark law, me as a seller, I can do puffing. I can exaggerate the virtues of my product. This is the best soap in the world. This is the best car in the world. You bathe with this soap and your skin will become like Juhi Chawla. Lux always says Juhi Chawla and Deepika Padukone and Aishwarya Rai and God knows who else. Your skin ऐसी हो जाएगी. Okay? All these ladies beauty products सब ऐसे ही advertise करते हैं कि आपकी skin ऐसी हो जाएगी, Celine Dion जैसी हो जाएगी और Julia Roberts जैसी हो जाएगी and all of that. Susan Sarandon जैसी हो जाएगी, depending on what age group you are. Okay? So सुष्मिता सेन जैसे आप फिट हो जाएंगे अगर आप इस जिम को ज्वाइन करेंगे. You are allowed to do all of that. You can show your product to have virtues which your product does not have. But you cannot show another person's product in poor light. That is not allowed. That is infringement of a trademark by virtue of section 29 subsection 8, which is called comparative advertisement. आप comparison draw नहीं कर सकते दूसरे का which shows him in poor light. So what people do nowadays in the FMCG space, you will find people coming up with surveys, studies, right? That, you know, so Hyundai will say that, okay, these are the 10 parameters I am better than Maruti. You can make that comparison. Let's say there are 20 parameters, 20 में से 10 में आप अच्छे हैं, 10 में आप खराब हैं. आप केवल वो 10 बताइए जिसमें आप अच्छे हैं, that is allowed. No problem with that. But you cannot say don't buy Maruti. As Hyundai, you can say that I am the best. These are the 10 things in which I am better. But you can't say don't buy Maruti. You can't say don't buy Maruti. Remember the case wherein Nestle had problems, noodles, the MSG, monosodium glutamate. Patanjali started saying that our noodles are MSG free. And they started advertising with this one, Nestle packets. Not allowed. ये बहुत ज्यादा होता है, कोलाज के केस में बहुत ज्यादा होता है, एक उसमें होता है एफएमसीजी बहुत सारा रोज. I can give you n number of examples. There is that Ujala case which is there. A person uses that, he goes to class and his friends say kneel 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 because his shirt, white shirt has become blue. So आप जो है किसी bleach का ऐड कर रहे हैं और आप उसको दूसरे रॉबिन ब्लू को खराब बता रहे हैं. Then there is that thumbs up ad, Akshay Kumar. There is a child who is standing. He says, "Come here. There are 2 drinks." He says, "कौन सी पसंद आएगी?" Pepsi का ad है, यही है right choice baby. And he comes, the child chooses this one. बच्चों को कौन सी पसंद आएगी? ये. क्यों? क्योंकि ये मीठी है. And then he picks up the drink. And then Akshay Kumar turns it around and he says, यही है wrong choice baby. And the child does this as if he's made the wrong choice. Not allowed. Courts have said these things are not allowed. So we cannot show another person's product in a poor light. I think with this, I have come to the end of my whatever I had planned. So if there are any questions, I'll be very happy to take them up because I like an interactive session. So I'll be very happy if there are any questions. Pooja ji.
Ji sir, we have got 3 questions till now, though I will be requesting all the participants, if they have any question, they can raise their hand, they can write that those questions in Q&A section or chat box. So whichever way is convenient to you. So I will be taking the first question that is there from the side of Dr. P.C. Jena. He writes, why plagiarism or copyright cases are very nominal in India? Sir, please share your experiences.
Sir is absolutely right. As I mentioned, this is a very nascent area in India, but sir, things are changing. In the last 20 years, I have seen quite a bit of development in this side. Before Fateh Singh Mehta, nobody in Indian high courts or Supreme Court was even talking about plagiarism. किसी को पता ही नहीं होता. In fact, I have even seen professors getting articles typed out. ये यहाँ से इतना कॉपी कर ले, वो वहां से इतना कॉपी कर ले और नीचे ना footnote मैं डाल दूंगा. I have seen that also, sir. So it used to be happening, but it is my feeling that things are today very different, and they will be even more different 10 years later. That is because, sir, now we are forced to become very strict because what is happening is that many publishers, etc., they are becoming very strict, and so that is why. And our international, I mean, the awareness. See, in India, actually, what is happening is that previously there was no, even in Delhi University, can you believe it? Till about 10 years ago, 15 years ago, IPR was not being taught as a compulsory subject in law. In many universities in Rajasthan and UP, even today, it is not taught as a compulsory subject in law. So the awareness is just, forget that. I have been going to the Delhi Judicial Academy to train judges, etc. It is not their fault. They have never been taught it. So how will इनको basic elementary knowledge भी नहीं है. उनको ये पता ही नहीं होता कि ये crime है और क्यों crime है. So these are the certain things which are there. Yes, while making the law, care has been taken that these cases should be investigated only by police officers of a certain rank, not the ordinary constable. Usko kya pata? And similarly, they should be tried by nobody less than an ADJ, additional district judge, not an ordinary magistrate. So these things have been done in the law, but yes, I agree with you, sir, that the awareness is very low as compared to, I remember going to Australia, going to UK. At every computer in the library, there is a notice about plagiarism, and which is not the case here, but things are changing, sir. That is what I would say. Sir, you are on mute, sir. I think Jaina sir was wanted something.
No, sir, thank you, sir. So thank you for your information. Thanks a lot.
Yeah, thank you, sir. Thank you, sir.
So, sir, we are having second question from the side of Dr. Neetu Chawla. She writes, what are the cookies which certain website uses? Is it a part of copyright? Any limitations or exceptions to copyright?
Very interesting question. And see, cookies are originally supposed to be meant for the purpose of customizing or making your website experience, browsing experience better. Having said that, I mean, the whole purpose is so that you shouldn't have to write the same information again and again. Having said that, without your permission, if somebody is storing your information, it is illegal. It is not only a violation of copyright, it is also a violation of data protection laws. So they have to clearly specify their privacy policy. इसलिए किसी भी website पे सबसे important चीज होती है उसकी privacy policy. And also, if the website is storing your information in the form of cookies, they must say that what the cookies are going to be meant for, how you can modify it, so on and so forth. So yes, that is your right.
Sir, we are having the third question from the side of Ms. Manju Kundu, ma'am. The question is, do I have to cite resources from every fact I use, for every fact I use, and can every fact be copyrighted?
So see, the good practice which I will suggest is that anything and everything which you take, in fact, it will make your research good. I remember some very senior professor had told me when I was doing my LLM dissertation, he says, देखो ऐसा है, अगर तुमने 30 फुटनोट डाले तो तुम्हारी रिसर्च को बेकार बोलेंगे, 300 डाले तो बहुत अच्छा बोलेंगे. So I use that as some kind of a guru mantra even today, because it is in your interest. The footnote is your protection. जितना ज़्यादा आप footnote डालेंगे, it is better. It is not only making your footnote rich, I mean your research rich, but also saving you from any kind of action later on. In fact, you know, many a times we use tables, we use pie charts. What is the harm in saying source Bangladesh yearbook, source CIA fact book? क्या problem है? उसमें कर दीजिए ना. So it is good. In fact, I would strongly encourage you to do so.
I would request all the attendees, if they are having any question, they can ask. Here they can raise their hands also, they can write that in chat box or question and answer section also, so that the question can be taken up and will be answered by our dear sir.
Because this is both of these are actually very developing areas. And so one more area of development these days is the area of overlap. So maybe at some point of time you can have a session on that, the interface of copyright with trademark, or the interface of trademark with design. So these areas are now coming together. They are no longer operating as standalone areas. So now shape trademarks have been recognized. A very interesting case. Justice Dhananjay Chandrachud, now in the Supreme Court, when he was in Bombay High Court, he has given protection to a shape trademark. The very interesting case. The name of the case is Gorbachev Vodka versus Messrs. John Distilleries, and there is the whiskey bottle. I mean, and both the products are for well-heeled people, for well-to-do people. So there is a whiskey bottle which has a particular shape. Now, very interesting. The shape is a bulbous onion dome shape, which is the shape of Russian Orthodox churches of the 15th and 16th century. Even today, if you go to Russia, and you will see those churches, 15th, 16th century built churches. So, unka shape वही था, and he was selling vodka by the name of Gorbachev vodka. The other fellow is Messrs. John Distilleries. He was selling whiskey by the name of Salute. His bottle was again bulbous onion dome shape, only it was slimmer. Vodka bottle was fatter and shorter. And this company says, look, this is my unique design. It is functioning as trademark. And people come to me because of this. The judge says both of your products are niche products, available at duty-free shops and so on and so forth. The chances of confusion being relatively less, but still I will go ahead and give protection to this mark as a shape trademark. So what he had said at that time, it has now been incorporated into law in 2003. So is tarah ki cheezein, the overlap with the trademark and this thing, maybe some point of time you can have a program on that, because that is a very developing area. I think Jena sir has raised his hand.
Yes, sir, am I audible?
Yes, sir.
Sir, just I need your clarification. Suppose our students are doing some sort of dissertation or PhD thesis. They are using some sort of standardized test. If a student will take the printout copy of any standardized questionnaire, is it under Copyright Act, or what type of permission they require to do?
So, very good question, sir. Again, if there is a standardized questionnaire from whoever has prepared it, see, the Copyright Act allows you exception for educational purpose. That is, I think 52(1)J or 52(1)H, something like that it is there. Because 52 is the section which is exceptions. 51 talks about infringement. 52 is I think it is 52(1)H. So, which is the one which deals with what you have said. However, sir, if somebody were to object tomorrow, it is better that we today only obtain permission, and most of the time nobody will deny permission. I will give you an example. Me and another colleague, along with some two professors in the computer science department of Delhi University, we were trying to do something on creating, using artificial intelligence to have case summarization. So let us say there is a decision of the Supreme Court running into, because Indian judges are very verbose. So they will write 400 pages and 1000 pages and all of that. Now, most people don't have that much of patience, even if they are interested in the law. You read Ram Janam Bhoomi judgment, 1200 pages. You need Indira Sani on reservation, 1200 pages. Keshwananda Bharti, 1300 pages, fundamental rights case. So to sum those up into maybe 30, 40, 100 pages, whatever. So we try to use our models which we have created using artificial intelligence on that. And these text of the judgments are available on various paid subscriptions like SCC Online, etc. So we wrote to them, sir, on email and saying that we want to use it for this purpose. We will acknowledge you. They said yes. So I would say, sir, if there is a pre-prepared questionnaire, there is no harm in asking. Most of the times they will say yes. And if they have not said yes also, as long as they don't say no and you have sent an email or a letter, then you are, so to say, covered, sir. You have done your bit till they don't say no.
Thank you, sir. Thanks a lot.
My pleasure, sir.
Sir, I cannot see any question in the chat box or question and answer section. I think we should proceed with the session, and I thank you, sir, for taking and clearing all the queries from attendees or panelists. We are really glad to have you here. Thank you, sir, for helping us understand the concepts of copyright, plagiarism, trademark better. We have learned about many facts related to these concepts that will help us to grow ourselves as a professional. Sir, we really like the appropriate and interesting real-life examples quoted by you to clarify the points further. So thank you, sir, for enlightening this session by your kind words. Thank you, sir.
Thank you very much, ma'am. Thank you, sir. Thank you.
Thank you.
Thank you so much, sir.
Now I hereby invite our very own Dr. P.C. Jaina, Academic Coordinator, Associate Professor in School of Education, K.R. Mangalam University, to give vote of thanks.
Thank you, madam. First of all, I am very, very thankful to our team to nominate my name for vote of thanks. Really, it is an opportunity for me. And I was associated from the very beginning at the end of the session. And I learned so many things. कभी मैंने ये चीज सुना नहीं था, कभी मैंने ये केस भी रियलाइज नहीं कर रहा था. और ये सेशन पे मैंने एक स्टेटमेंट पे फ्रॉम ए लेमैन पॉइंट ऑफ व्यू में मैं एक स्टेटमेंट से शुरू कर सकता हूँ. जब नकल करना तो अकल से करना, otherwise you may get some sort of difficulties or constraint or hurdles. So, sir, you have already covered our very, very essential points of copyright, plagiarism, trademarks, and these, your knowledge will be more beneficial for our research scholar, our teacher, or especially those who are preparing different type of research project. And many times these things are very, very necessary to handle or tackle, to bring some sort of authenticity or originality. And you have also focused copyright, moral right, economic right also, and Paris conventions, and you have focused so many things. Suppose, for example, मेरे को भी इतना पता नहीं था, जैसे मालदीव है और भूटान है, इसमें ट्रेडमार्किंग सिस्टम जरूरी नहीं होता था. So definitely your idea, your sharing experience will be beneficial for our faculty members. And many thanks, sir, for sharing your information. Despite your busy schedule, you accept our invitation and join with us. And definitely from our school or faculty member will keep in touch for future, any type of help they need. I am also very, very thankful to our management, leadership team, especially Vice Chancellor sir, Pro Vice Chancellor Madam. I am also very, very thankful to our Dean Madam Professor Tanya Gupta, and she is always very initiative and to organize so many type of conference and seminars. And I am also very, very thankful to our media teams and technical teams, and many thanks to our organization teams. Special thanks to Puja madams and other associated members. Thank you, sir. And I am also thankful to all the participants, those who are associated in the 5th day of the faculty development programs. And definitely this type of session will be more beneficial for their future life. So thank you again, sir. Thank you for enlightening us. Thank you, sir. And we will keep in touch in future. Thank you. Namaskar.
Thank you, sir. Thank you for having me, sir. Thank you, sir.
So much. Thank you, Dr. Parikshet ji. Thank you.
Thank you, sir. Thank you, ma'am. So I will be heading towards ending this session. Thank you, everyone. Thank you.
Thank you, ma'am. Thank you, sir.
Thank you, sir.